Judge, may I open court?
Please. Thank you, Anne.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3075, United States of America versus Brynee Baylor, appellant. Mr. Sukumar for the appellant, Mr. Datterman for the appellate.
Good morning, counsel. Mr. Sukumar, when you're ready, please proceed.
Thank you. Good morning, Your Honors. May it please the court, Sean Sukumar on behalf of Ms. Baylor. Your Honor, I think we're presenting a single issue before the court today, and that is on the question of the government's misstatements and speculation during closing arguments in this case, and whether those misstatements substantially prejudice Ms. Baylor's defense, and whether the court can find that those misstatements did not affect the jury's verdict in this case. And if so, if the court cannot find that those misstatements did not substantially prejudice Ms. Baylor's defense, then the court must vacate Ms. Baylor's conviction in this case. And Your Honor, just to briefly state the background here on Ms. Baylor's defense, which is that central to the defense argument in this case is Ms. Baylor being an unwitting victim of Frank Lorenzo, also known as Frank Pavlico. And central to that argument that Ms. Baylor did not know that Mr. Lorenzo was engaging in a fraudulent scheme to bilk investors out of money. That central to that argument is not only the information that Ms. Baylor had that resulted in her trusting Mr. Lorenzo and other people that she had heard from that told her that Mr. Lorenzo was to be trusted, that it resulted in her, Ms. Baylor, encouraging and getting her mother to invest in the same transaction that other investors had invested in. Her mother's investment, unbeknownst to Ms. Baylor, was then also improperly used, and that was a central argument at every single stage of Ms. Baylor's defense. Was that if other investors had known about the fraudulent conduct of Mr. Lorenzo, would they have had their own family members invest in this scheme? And this was a question.
Mr. Sukumar, can I ask you a question? So this factual predicate that you're laying before us and where you started off was that the court would have to find that the statements by the prosecutor did not affect the result, as opposed to putting the burden the other way to show that you'd need to show that it did affect. And on that, I'm trying to understand your claim of error, because in your reply brief, you say that the government's incorrectly saying that Ms. Baylor is appealing the denial of the new trial motion. And so you're not apparently appealing the denial of the new trial motion. But if you're not appealing the denial of the new trial motion, what's the asserted error that you're bringing to us?
Yes, Your Honor, it is correct. We are not appealing the denial of the new trial motion. We are asserting that the error here is the government's incorrect statements presenting speculative arguments as fact in the closing arguments at the very end of the case.
Right. So, but with respect to that, so the prosecutor made some statements and then an objection was raised. And then the objection was sustained and the court took action. So I'm not quite following how you can say that there was an error as to which the government has the burden to prove harmless error if you actually made an objection and the objection was sustained because you won. And then after that, I mean, in theory, you could say, well, the trial court should have done something more. District court should have done something more than what was done. But you got a remedy, you raised an objection, you got a remedy. if the district court should have done something more, I didn't see anywhere where counsel at trial had objected that nothing more was done. And if that's true, then it's not clear to me what the error is that you would claim such that the burden would be on the government to prove harmless error. Typically in this kind of situation, the way it arises, like in some of the cases you raised, is that prosecutor will make a statement, the defense will raise an objection, and the objection will be denied. And then if the objection is denied, then you could bring the claim on appeal and say that was an error. And if the court agrees on appeal that it's an error, then the government has the burden to show that it's harmless error. But here the objection was sustained, it wasn't denied.
Yes, Your Honor, and that's correct that the three objections that were leveled against the government statements, they were sustained, but our argument here is that that alone was not sufficient to be able to cure the prejudice to Ms. Baylor. And I think the reason why here and why it relates to these specific statements.
Well, can I just stop you just really quick? And
Sure.
if your claim is that that wasn't enough to cure it, but you didn't say that at trial, then I'm not understanding why the government has the burden on harmless error, because that seems like a plain error issue, because the objection wasn't raised. Because you did raise an objection, it was sustained, and then if you think something more should have happened, like say you thought a mistrial should have been declared, but nobody asked for a mistrial. And so at that point, it seems like the burden is on you to overcome plain error, because now you're talking about something as to which there wasn't an objection as opposed to something as to which there was.
Your Honor, Ms. Baylor disagrees that that the objections that were leveled against the misstatements did not preserve the issue to the point where that she now has to assert plain error. We disagree that plain error is the correct standard here as opposed to harmless error. The objections that were leveled by trial counsel sufficiently preserve the issue. And I think the reason why they preserve this issue is because they were all directly related to the same issue, the same kind of misstatements where there was speculation on the same issue. And it was the same issue that was central to Ms. Baylor's defense. And because all three of the objected to statements were of the same type, this was a general objection to the types of statements that the government was trying to make, where they speculated on possible alternative explanations to a stipulation, none of which had been admitted at trial, none of which were testified to or otherwise in evidence.
The government, as I read the transcript, never made a never misrepresented what the stipulation stood for.
Your Honor, the misstatements here, the central part of the misstatements.
But in fact, I think defense counsel did misstate the what the stipulation said. As I recall, the defendant's counsel said that the stipulation showed that this Baylor's mother invested in this, whatever it is, fund. But the stipulation doesn't say that, does it?
Your Honor, the stipulation, and this I think goes to the instructions on how the jury is to perceive the stipulation, which is that they are undisputed facts. And this is why the defense...
No, you're missing my point. Maybe I haven't made it clear. The only thing the stipulation says is that the mother gave $15,900 to Miss Baylor, and that for whatever the purpose was. And then later, Miss Baylor says that this other fellow told her he invested it. That doesn't prove that it's been invested at all. And it's double hearsay anyway.
Your Honor, I think while it's true that those facts alone don't necessarily prove anything, and the jury was left to decide who they credited and who they didn't credit, the point is that the government made arguments and made possible explanations for alternative explanations for what happened to that investment or what happened to that money that were not raised at trial.
Why isn't that just fair argument? The government didn't misrepresent the so far as I can tell, the stipulation, and then asked the jury to draw certain inferences in light of the context and the date and the fact that Ms. Baylor knew by then that she was under investigation. On the other hand, the defense is asking the jury to draw inferences from the stipulation, namely the main one being that no daughter would have her mother invest in a scam operation, knowing it to be a scam. So you're drawing one inference, the government wants another. I don't see where there's even error at all in this.
And I think this goes to where at trial the defense actually didn't object to certain inferences or certain arguments that were made about, for example, inconsistencies between how Ms. Baylor approached an investment from her mother compared to other investors. The government raised multiple issues related to differences in the documentation that applied to some investors versus her mother. None of that was objected to because the defense felt that that was all fair lines of questioning and fair lines of argument. The only issues where the defense objected to was when the government stated, for example, a presumption that Ms. Baylor's mother was trying to help her daughter, not presenting that as a possible argument, not asking anyone to testify to that, or not eliciting that information at trial from any witnesses, but presenting that speculation as fact that Ms. Baylor's mother wants to help her daughter, for example, or that this money was for a mortgage statement or was for household expenses. Presenting those arguments as fact, especially during closing arguments when there'd be no additional testimony to challenge it and no additional ability to be able to call any additional witnesses on those matters, that is where Ms. Baylor is substantially prejudiced. And I think this is especially important on an issue where
Let me ask if my colleagues have further questions for you, Judge Baylor.
I did want to ask back. I had some of the same confusion that the Chief Judge was asking about of what it is, both the standard of review, which I don't, for the reasons that the Chief Judge mentioned, I'm not sure I see why you think it's the government's burden, but I'm also curious, what relief are you seeking in the brief at Romanet 1, when you describe the ruling under review? You say this is an appeal from the misstatements and that it warrants a new trial. But then elsewhere, you seem to be saying that the conviction should just be vacated. And I guess those aren't mutually exclusive. But again, the clearest way I understand this record is that it's an appeal from denial of a new trial, and that the burden is on the defense to show that the district court did not abused its discretion in denying a new trial.
Your Honor, we see the first issue that the court should consider here as being whether Ms. Baylor is substantially prejudiced by the government's misstatements.
Can I first ask, what relief are you seeking? Are you seeking a new trial?
Yes, we are seeking a new trial. We're seeking to vacate the conviction and grant Ms. Baylor a new trial, correct?
Okay. And the reason that it's not, that the standard for our review is not that the district court abused its discretion in denying the motion for new trial, your reasoning for that not being the correct standard is what?
Your Honor,
the objection granted?
Your Honor, the way that we see it is that the sustaining of the objections did not cure the misstatement. It did not eliminate the misstatements. And the reason why
defense didn't ask at the district court for any further curative instructions.
No, those arguments were eventually made in the motion for new trial. And that's correct that the arguments there were eventually made in the motion for new trial, but we do not believe that that is the starting point for the court's consideration. We believe that the starting point for the court's consideration should be on whether the misstatements by the government substantially prejudiced Ms. Baylor before even getting to the question of abuse of discretion, and that if the statements substantially prejudice Ms. Baylor, regardless of whether the defense made any additional requests for any additional jury instructions, and regardless of whether the objections were sustained. The presence of the statements at that pivotal time in the case, at the question of rebuttal on a very specific issue related to a stipulation, as the last thing that the jury heard, whether that substantial prejudice was error to the point where it was not harmless and requires reversing the conviction. We believe that that is the primary question here.
Okay, maybe unless my colleagues have additional questions at this time.
No, thank you.
We'll hear from the government. We'll give you a little bit of time for rebuttal.
Thank you.
Mr. Detterman.
Thank you. Good honor and good morning, and may it please the court, Mark Detterman for the United States. I'd like to first address the stipulation. The stipulation in this case was a stipulation of testimony. It was a stipulation of what Ms. Gandhi testified to in the SEC deposition. It was not a stipulation of fact. If you look at the stipulation itself, it uses the word testify 5 times. Every single sentence is Gandhi testified that she spoke to Frank Lorenzo. Gandhi testified that she gave Baylor a check for $15,000. Gandhi testified that Baylor told her that Lorenzo had received the money. And if you look at during the first day of trial, defense counsel himself characterized the stipulation in this way. And this is April 19th afternoon transcript 3536. He said, Andre Gandhi, that's Ms. Baylor's mother, and Ms. Baylor's mother is unavailable to testify today. She unfortunately has Parkinson's disease, and so she's unable to testify here, but she testified in a prior hearing, and the parties have stipulated about what she would say. That's how defense counsel characterized the stipulation on the first day of trial. So again, this is not, the government did not agree to a stipulation that Gandhi made an investment in Milan Group. The government simply stipulated to a summary of what she had testified during the SEC deposition. That was one issue addressed. The second issue is the standard of review that I like to quickly address. And that's defense counsel appears to be trying to get around the abusive standard, a standard of review of abusive discretion or clearly erroneous on the factual issues by saying they're not appealing the district court's denial of their new trial motion. But if that's true, which makes no sense, the district court ruled on these matters. The district court found that the government had not misstated the evidence. The district court ruled that even if it was improper, the case was not close and the evidence was overwhelming and that it would not have changed the verdict. So the trial court made findings on those errors. But if we somehow ignore that and go back to the trial transcript, as Judge Srinivasan said, that their only objection was speculation. They didn't ask for a new trial. And so here they're going way beyond speculation. Not only are they claiming that the government violated the stipulation, they're claiming that the government misstated the facts, which they didn't say at the time, and they're asking for a new trial or a mistrial. And none of that was raised during the trial, and thus the standard would be plain error. And again, the standard in any case is very high. In Borda, this court said that we would only reverse a trial, grant a new trial on a prosecutorial, on a comment of a prosecutor if the statement so infected the trial with unfairness as to overcome the jury's ability to rationally weigh the evidence. And in the statements made by the prosecutor, which were about bias and which were about whether this was really an investment or not, and both of those were based on the evidence, the prosecutor's comments were not inflammatory. They were not meant to play on jury sympathies or emotion. They were simply arguments that, one, Baylor's mother might be biased in favor of her daughter. And that was based on the evidence. Baylor herself testified that she had a very close relationship with her mother, that her mother had been living with her, and that she was taking care of her mother through her mother's illness. The second part was whether this was an investment or not. And again, this was based on the evidence. The investment wasn't just a $15,000 check. It was two checks. There was a $15,000, $563.20 check written from Baylor's account to Frank Lorenzo. So an odd amount that was written to Frank Lorenzo from Baylor's personal account. Then 2 weeks later, there was a second check for $15,900. And Baylor admitted that she filled out that check on her mother's account and had her mother sign it. And that was deposited in Baylor's personal account. So the government's argument that this might not have been an investment, that there might have been money transferring from the mom for household expenses or something like that, it wasn't pure speculation. It was based on the evidence that was presented at trial.
Thank you, Mr. Detterman. If my colleagues have no questions for you, we'll give Mr. Sukumar his rebuttal time.
If we were to assume that the standard from the closeness, centrality, and mitigation is the right way to look at the issue about whether this prosecutorial statements substantially prejudice the jury, the government doesn't really argue that the disputed issue as to which the district court sustained the objection was an issue central to the case, does it? I mean, the question whether or not Baylor had the requisite mens rea and this issue about the purpose of the check, was it an investment or not, that's central to the case now.
Your Honor, I understand your point. I mean, obviously the mens rea of Baylor and whether she thought this was a real investment is something that was central to the case. However, the $15,000 investment is a very small part of that. It's $15,000 out of $2.4 million. Also, Baylor herself, she testified for 2 days, and the testimony about her mother's investment was only 4 pages of that transcript of 2 days. And she essentially denied that she made any of these promises. Over 2 days, she denied she made these promises to the investors about their money being safe and then they would get a high return. And that was contradicted by 9 victims that testified that they lost all their money. And so even if, mens rea is central, but this $15,000 investment is such a small part of that, that so, I think it's hard to say that's.
Yeah, I'm sorry to interrupt. That's helpful. I mean, the district court says it's not a close issue, in part pointing to all the other evidence, yes, and some of the facts that you characterize. But I guess that really helps highlight my question about centrality. Do we look at whether the issue here, the mens rea, is central to the case, and that's the issue on which the disputed comments bear, or do we look more narrowly at whether the role that the erroneous statement might have played could be central? Or is that really mixing closeness and centrality? I'm just trying to get, is centrality, how generally or particularly do we apply the centrality?
I think the closeness should matter, like how much of the mens rea, how important this issue was to the mens rea proof. Even if the jury believed that there was a $15,000 investment by her mother, they still would have convicted her because they have all these statements that show that she was immediately taking this money out of the trust fund account. And she knew she was taking it out and spending it. So she knew that this was fraud. The bank records show that. So even if there was some investment by her mother, I don't think that wouldn't have even made a difference in the outcome. It might have been just for show. In fact, to one investor, Baylor bragged that she had she personally was invested in these funds. Although the only evidence really is that her mother invested in these funds, if, according to defense counsel's argument. So, I mean, this is such a small part that I don't think it's central. I understand that the mens rea is certainly central. Yeah, I'm not sure how you parse that. I think it's it's an interesting, arguable question. Thank you.
All right. Thank you. Unless my colleagues have additional questions for you. Thank you, Mr. Detterman. Mr. Sukumar, we'll give you 2 minutes for rebuttal.
Thank you, Your Honors, and I'll be very brief in this situation. Your Honors, where the government errs in their argument here is, I think, in a couple of places. One is whether the question of the specific amounts of the claimed investment by Ms. Baylor's mother in relation to the total amount of money has any relevance whatsoever to the question of whether Ms. Baylor had the requisite mens rea to know that the scheme was fraudulent. And the two we would propose are just completely unrelated to each other. The central argument here from Ms. Baylor is that she did not know that this scheme by Frank Pavlico / Frank Lorenzo was fraudulent, and that she would not have gotten her mother's money involved. And this is what she testified to. And this is something that the jury had the ability to obviously weigh credibility between Ms. Baylor, between the government's witnesses, and between the claim from Ms. Baylor that her mother's money was invested in the same funds, in the same transactions that their money was in, according to what she testified to as her belief and her honest, genuine belief at the time. And it's that belief that is the central part and the central issue of the defense, not the specific amounts of money, not whether the statements were central to the government's case. The government's case can be whatever it wants to be. The central issue for the court's consideration is whether this was central to Ms. Baylor's defense. And it was not only central to Ms. Baylor's defense, but the government's statement substantially prejudiced her ability to be able to make that defense in a way that could not have been cured by the objections. It could not have been cured by the government, by the final jury instructions. And that is why we're asking that Ms. Baylor be granted a new trial.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 17-5260 et al. State of Alaska, appellant, Alaska Electric Light and Power et al. Versus United States Department of Agriculture et al. Ms. Gramling for the appellants, Mr. Smeltzer for the appellees USDA et al., Mr. Fine for the appellees Southeast Alaska Conservation Council et al.
Morning, counsel. Ms. Gramling, please proceed when you're ready.
Good morning. May it please the court. My name is Mary Hunter Gramling, and I'm representing the state of Alaska, arguing today from Alaska's capital city, Juneau, one of the many communities negatively impacted by the prohibitions of the roadless rule. Alaska is joined in these consolidated appeals by local governments, utility and power companies, chambers of commerce, leading industry groups for timber and mining interests, and then other Alaska business interests. The appellants request vacatur of the roadless rule due to violations of Alaska's specific laws, the Alaska National Interest Lands Conservation Act, ANILCA, the Tongass Timber Reform Act as an amendment to ANILCA, and the National Environmental Policy Act. Alaska is different. The United States Supreme Court has repeatedly and recently recognized this fact in its recent Sturgeon v. Frost decisions. In the Sturgeon cases, the Supreme Court considered a restrictive national regulation that violated a provision of ANILCA. The court construed ANILCA according to its historical context and the purposes of the act overall. The court in Sturgeon discussed the background of protests of restrictive federal actions and executive actions that restricted development in the state and land selection rights that were under previous federal laws.
Ms. Gramling, I'd like to ask you about the sort of where we are today in the case. As you know, there's been briefing on whether the claims are moot in light of further consideration of the applicability or not of the roadless rule to the Tongass. And one of the questions that's sort of nested in or raised by the claim of mootness is whether Alaska has standing based on impact in the Chugach. And when I'm thinking about that, there was a motion to dismiss based on mootness, but the underlying case was at the summary judgment stage. So my specific question is whether the state of Alaska can point to any evidence, as opposed to merely allegations, that the claims here implicate any harm flowing from the Chugach. With the NEPA claim, if it were successful, remedy any harm to Alaska based on the Chugach. Would the Alaska Lands Act claim, if you were to prevail on it, remedy any identified harm in the record to Alaska flowing from events at the Chugach? And if you can help us out by pointing to the record where those harms are identified.
So as far as the Chugach is concerned, the Chugach is the second largest national forest in the national forest system. And so while most of the state's arguments, we do have some Tongass specific arguments, the state also made statewide arguments. And the impacts on the Tongass are just more outsized than the impacts on the Chugach in some circumstances, but the state's statewide claims still apply to the Chugach to the extent it's not a specific Tongass related claim. And so in the record, this is a case that's being reviewed under the EIS and the APA. And so the state views its standing to be self-evident based on its comments and participation in the rulemaking process. As far as evidence in the record, I believe the joint appendix page 50 deals with the Chugach, and then the state's complaint at paragraphs 55 through 57 also are specific to the Chugach. In the context of the motion to dismiss, the state also submitted an affidavit from its state forester that essentially said that he had reviewed the claims and agreed that they were still at issue as they were when we filed the complaint 10 years ago now. And then furthermore, in other cases, the courts in the Ninth Circuit specifically have found that the receipt of revenue sharing from national forests can give the state standing. And so while the Cake Ninth Circuit case, that was at issue there, the same would be true for the Chugach, is that the state does receive revenues, and those revenues or has the potential to receive those revenues. And that was detailed in the state's complaint. And then additionally with the Chugach, it is under the roadless rule prohibitions currently, and the roadless rule applies to approximately 98 to 99% of the Chugach. And so while the Chugach does not currently have as significant of a timber program as, say, the Tongass could have, or even other forests, that the roadless rule.
May I interrupt you, please? On the payment business, isn't it a fact that the state of Alaska would receive that whatever it is per year, 6 million or something dollars, regardless whether there was logging going on in the Chugach or not. It's set. It was set in the year 2000, 2001, and that payment will be made regardless of the roadless rule.
So the payments by statute are determined by activities in those forests, and so
it doesn't matter whether the roadless rule is there or not there. They're going to get the same amount, the same payment every year. So why is that? Where's the injury there?
The injury there is because right now, or at least in the recent past, the Rural Schools Act has set that amount, but that could go away, and then we would be under the statutory revenue sharing provision, and that is based on activities in those forests. And so the roadless rule prohibits, development and the receipt of those revenues. In addition to the revenue issue, though,
are you saying that the roadless rule would prevent timber exploitation and that the amount of the payment is calibrated to the degree of timber exploitation?
I believe it's based on the total revenues.
The total revenues from timber? Or I'm just having a little bit trouble following at a little bit more factual level. What is the activity that Alaska is claiming would change within the Chugach, and how is that change, what effect is that change going to have on Alaska? I think the closest that Alaska gets in being somewhat more particular is, as you mentioned, the declaration in response to the mootness briefing. But even there, it's not clear why some of the pest control and fire reduction measures are affected by the roadless rule. Are they being taken when the roadless rule doesn't apply, and then they're not taken when it does? There's just the relationship between the challenged provisions and the harms just hasn't really been spelled out, and that's where I think we could use some help.
So turning back to the land management type harms, the state is a neighboring landowner to areas of the Chugach National Forest, and so it has that, it has its own land management responsibilities, and then also private citizens within Alaska have those, have land that borders the Chugach, and so the roadless rule has impacted the state's ability to conduct its own land management, because the roadless rule to a certain extent prohibits the sort of thinning and removal of deadfall of trees that that then pests can then it sort of just is a problem that compounds. So the more dead trees you have, the more pests you have, the harder it is.
There's an exception. No, the rule has an exception for just this type of situation you're talking about. It does not prohibit roads going in for the purpose of preventing wildfires or clearing or safety or whatever. That there's an exception for that. The roadless rule doesn't affect that at all.
So the exception for safety, I believe, has to be there is more of an imminent threat than just a more proactive measure. And then also the roadless rule considered in the process having more of a lenient alternative that would have allowed for more active forest management to prevent pests and help curb wildfires. And instead, they limited the diameter of the thinning that could happen. So it was only smaller trees. But
where in the record, what are you pointing to that where the roadless rule is prohibiting the thinning that would otherwise be taking place?
So the exceptions, so I apologize for not having the exact record site for me, but there was a small diameter limitation on thinning, and in the roadless rule decision, they anticipated that even with that timber cutting would be.
Well, there's a small diameter exception in the rule, but I guess what puzzles me a little bit is what my colleagues are getting at, which is I didn't see anything in the affidavit that was submitted in the response to the motion to dismiss or elsewhere in the record that elaborated on how exactly this would continue to harm Alaska vis-a-vis Chugach. At this stage, there needs to be evidence to bear that out. And I'm not aware of anywhere in the record where there is evidence that bears out how there would still be harm.
So in the record, the state certainly submitted its comments, and those comments include harms to the Chugach and the land management decisions that would flow from that. But generally speaking, the lack of roads has led to less active management of the forests in the Chugach. And then so these issues of wildfires and pests reach potentially a greater scale than they would have otherwise if presumably if the roadless rule had not been in effect. The forest managers would have greater flexibility to account for individual forest conditions and allow timber to more timber cutting to address those. Commercial timber, I believe, can aid in the process of thinning and deadfall.
Do we have any reason to think that you mentioned that forest managers would have greater flexibility to do more timber cutting? Is there any reason to believe that it would in fact do more timber cutting for that purpose?
So historically, the Chugach forest did have a timber program, and due to infestations and some changes of tree types, I believe, the timber harvest shortly before the roadless rule was very, very low, but there's no reason to expect that in the absence of the roadless rule that it couldn't rebound. But going back to the standing issue, the state had reasons to believe that its standing was self-evident in the district court proceedings. And my understanding is that this circuit, if standing is a concern, that even after argument that you could take supplemental briefing, and the state would be happy to provide that. Turning back,
that would be helpful. I mean, if there's, I don't know what you're thinking about in the comments, but if there are specifics regarding the Chugach in the comments that you can identify, that I think that's, could be significant. But you can hear that we're struggling with the question of harm and also the question of whether it's caused by the roadless rule or by other factors and would be redressed were the state to prevail on this challenge. So we're really considering, I think, all those questions. And this is bracketing, assuming that there is a mootness problem, which is obviously not your motion, but because you're up first, and the standing question is an important one. That was helpful to hear from you on that.
So I'd like to turn to the mootness question. The state's position, of course, is that the case is not moot. The 2020 Tongass exemption rule that was published during the Trump administration, it has not been given any actual effect in the subsequent administration. The only effect that it's really had has been for the purposes of this litigation to say that it's in effect. For any activities to happen in the Tongass, the forest plan would have to be amended as was required by the rule. And that has not happened yet. The Biden administration has paused activities, and they've indicated that they're going to repeal and readopt the rule. So the state's position is that the federal government has a heavy burden to prove mootness, and that it cannot do so because it has voluntarily ceased the activity. And so it had to show that the harm has been repaired, which it has not, and that it won't recur. And so the federal government's arguments on mootness fail for that reason. Additionally, the relief requested for the Tongass in this case is a little bit different than the exemption rule. The exemption rule is under the premise that the roadless rule still exists. And so the relief the state is asking for here is to vacate the rule statewide and potentially nationwide. And so that would moot the Tongass exemption rule and then potentially guide the federal government in other new rulemaking that it is under. And so the state doesn't feel that the exemption rule has the same caliber of a decision that a decision from this court would have that finds the roadless rule should be vacated. And with that, I'll, unless there are further questions, I'll reserve my remaining time for rebuttal.
I have one question. What is the status of the lawsuit in the federal district court in Alaska claiming that the 2020 rule was invalid?
The federal government has, since I believe March, requested stays in that case. They have not filed an answer. The state has intervened in that case and filed an answer, fully intending to defend the rule if the federal government declines to defend it. We also, in that case, submitted some affidavits about more forest management particulars that I tried to recall here for you since that wasn't a focus of our briefing, but that is the status of the case at its state.
Okay.
At least November.
Thank you, Ms. Gramling. We'll hear from the government now, Mr. Smeltzer.
Good morning, Your Honors, and may it please the court. John Smeltzer for the Department of Agriculture and the Forest Service. Your Honors, the roadless rule is not presently applicable to the Tongass, and for that reason, we believe the challenges here are mostly moot. And the other challenges that aren't moot have the standing problems, because most of the claims here are Tongass specific, and all of the concrete harms that the plaintiffs in this case have articulated relate to the Tongass. So it's either as a combination of mootness with respect to the Tongass specific claims or standing. We believe the claims are not presently justiciable. To start with there's another problem too that you didn't mention, and that is we have a rule in this circuit that goes back to heaven knows when. One of the leading cases is by Justice Scalia when he was on the court, called Carducci versus Reagan. And the rule is that if you don't raise an issue and make an argument in your topside brief, then the court does not consider it. It's not good enough to raise it in a reply brief or even in an oral argument. And I don't see a single argument in the state's blue brief that was filed in 2018 that deals solely with the Chugach. It's all Tongass. Yeah, that's right, and it illustrates that the focus of their claims and their injuries are the Tongass. I think what Ms. Gramling would say is that the other claims are generally applicable to the roadless rule, and because the roadless rule applies to the Chugach, there's a violation that pertains to the Chugach. But to raise, there's a distinction, of course, between a violation of the law, right, and whether there's a concrete and particular injury, and it's the absence of the injury with respect to the Chugach that matters. And so while we're talking about the Chugach, let me talk about the two concrete areas that Ms. Gramling raised to suggest standing, and the one is the question of receipts on Forest Service land. And to clarify the law, there is a permanent statute at 16 USC section 500, which says the United States will share receipts that from a national forest with a state. It's a certain percentage. It's all receipts. It's not just timber receipts, but it's a receipt sharing statute. And then there is a public law that Congress has repeatedly reenacted that allows an alternative formula for states to receive an alternative payment in lieu of that receipts in recognition of the fact that timber receipts were dropping on lots of forests. So that it's that in lieu of that allows states to receive a permanent payment that's not based on the actual receipts. And as Ms. Gramling said, there's a possibility, of course, that Congress doesn't, reenact that, but that has been reenacted, and that's been a part of the program. In Alaska's complaint, they say they received receipts in 2009 on the Chugach. But in 2009, of course, the Chugach was subject to the roadless rule. And the complaint doesn't say whether those receipts were under this alternative program, what the receipts were from, or how the receipts would be impacted by the roadless rule. And as Judge Ballard mentioned, I mean, the allegation that you received receipts is not the same thing as the allegation that application of the roadless rule is going to diminish those receipts. Again, those receipts that are named in the complaint were receipts when the roadless rule was applicable to the Chugach, and there's no argument that the application of the roadless rule is going to change the state's receipts. That is different than the circumstance that the state refers to in the Village of Cake en banc decision, where the Ninth Circuit found standing with respect to receipts on the Tongass. There, the Ninth Circuit specifically found that application of the roadless rule to the Tongass would affect the receipts that the state received. There is no allegation of impact with respect to receipts in this case. The other
is an allegation enough? This is a variant of the question that I asked Ms. Gramling. It would seem, since the underlying litigation is at the summary judgment stage, not the pleading stage, that what's needed is pointed to some kind of evidence.
Yes, Your Honor. And I think at this stage, an allegation would not be sufficient. But to the extent that the allegation is, it's not sufficient either, right? I mean, even if they could prove the facts as alleged, we received receipts in 2009. It doesn't say anything about whether they're injured by the roadless rule. And so the second area that Ms. Gramling spoke to was the question of the neighboring state lands and the question of whether management on Forest Service lands impacted management on state lands. And the suggestion in the complaint is that the lack of flexibility in the roadless rule prevents the Forest Service from doing fuels treatment and vegetation treatments that would minimize effects of wildfire. As Judge Randolph noted, there are exceptions that allow those kind of activities to go forward. There is generally, those exceptions are related to generally small diameter trees, but there's no, again, allegation or evidence that the type of fuels treatment that would be needed in the Chugach would be prohibited by, harvest treatments pursuant to the exception. I do want to note one thing, though, with respect to the exceptions. It is an exception on the treatments themselves, not an exception on road building. So the exception on road building, to be fair to the state, applies only to where there's an imminent risk of fire, exactly. and not to just the general advanced treatments. But what I want to emphasize for the court is there is a lack of any specificity in the allegations by the state that the absence of the ability to build roads with respect to treatments is impacting what the forest would do or impacting state management. And the state points to the forest plan for the Chugach in some of its briefing on the mootness issues. In the forest plan, the recently completed forest plan for the Chugach, there's also a whole section on fire conditions of the forest and fuels treatment and the like. And that data, which the state didn't refer to, represents that natural fire is not a significant concern on the Chugach. The much greater concern is human-induced fires in the wildland-urban interface, where there are roads and the ability to come in and do treatments. This information, I have to say, obviously is not in the record, not before the court, so I don't want to be unfair to Ms. Gramling. But what I want to illustrate is that the specifics as to the need for fuels treatment in the Chugach are not before the court in the allegations that are made and are relevant to this question of, would this the application of the roadless rule really change what the forest intends to do with respect to a fuels treatment, or what they can do. And I would submit there is no evidence that there would be any difference with respect to what the forest can and would do to protect the at-risk communities in and around the Chugach. With respect to the Tongass specific claims, we submit that those claims are moot because of the nature of the claims, right? The NEPA procedural claims have in effect already been, any relief that could have been granted has already been granted, right? Because the agency has already gone back and done a complete new NEPA review of the impacts of applying the roadless rule to the Tongass in the course of the 2020 Tongass exemption. And
I have a question about that, really more, and maybe this is just all premature, but just conceptually, if the 2021 proposed de-exemption of the Tongass were to, in effect, revive the impact of the 2001 roadless rule, then it would seem that the procedural soundness or not of the 2001 rule under NEPA could be a live issue. And I'm just not sure how to think about, and again, maybe, as I said, maybe this is premature, but how to think about what the proposal is. You know, for example, if it is a proposal to just take away what was granted in the 2020 rule, then it would seem that the NEPA claim, as dated as it might feel, is a live claim as a formal matter.
Your Honor, I submit it wouldn't be, because even if that's what the Forest Service does, right? It just says no more exemption, roadless rule applies again. It's done as part of a rulemaking, and as part of that rulemaking, the Forest Service has to consider, you know, everything they had to consider back in 2001, right? But they've already created a whole new record on that, and they've already, you know, part of Alaska's claims are, well, you didn't look closely enough at our concerns about the Tongass. Well, Alaska raised all of its concerns about application of the roadless rule to the Tongass in the most recent, rulemaking on the 2020 exemption and in the NEPA review of that. And so they had a whole new chance to consider all of those things. Alaska says, well, you didn't take enough time in 2001. Well, you know, now we've taken a whole lot more time, right? And there was a whole new procedure. And so ultimately the NEPA analysis is going to depend on how Alaska renewed its concerns about the application of the roadless rule to the Tongass, and how the Forest Service evaluated those claims in the context of the recent rulemaking, in addition to the old rulemaking. The old rulemaking is still relevant, of course, but obviously there's been an entirely new record that's been generated, and the Forest Service will have to look again at additional concerns and whether there needs to be any update to the NEPA analysis. And to review the 2001 concerns about the timeline, did they spend enough time? Did they consider, when we brought up this particular issue, just doesn't resonate with respect to the fact that there's a brand new opportunity, a brand new record on that. With respect to the Tongass Act itself, there's similar concerns. It's a substantive claim as opposed to a procedural claim. But if you look at the claim, the way Alaska is raising it in their brief, it's a very record-specific claim. They're not saying that you can set the roadless rule next to the Tongass Act, and a statement in the roadless rule conflicts with the Tongass Act. In order to find the conflict that they claim, you have to look at, what are the impacts of this rule on the Tongass, and most specifically, what is the status of market demand, and whether the forest can meet or seek to meet market demand on the Tongass from areas outside of inventoried roadless areas. And again, there has been a complete new evaluation of market demand in circumstances in relation to the exemption, and in relation to the forest planning rule, or the forest plan that came out, I believe, in 2016. And so the market demand calculations have all been updated, and the most recent market demand calculations suggest that the National Forest can actually meet, and of course the issue is seek to meet, but can actually meet market demand from outside inventory roadless areas. Now, I know Alaska is going to dispute whether those demand calculations were done correctly, right? But again, whole new record that has not been looked at by any district court, and we submit that the proper course would be, to the extent the Alaska still has the claims that it raised in 2001, they should be raised on the current state of affairs with respect to.
I mean, that's sounding, even though you labeled it substantive instead of procedural, that's sounding like, in your view, the reason the claims are moot as to that Tongass specific act are parallel to the reasons it's moot with respect to NEPA. So it sort of sounds like it's procedural.
Well, whole new record for both, right? Whole new record, whole new
So-
decision on both. So
From your perspective, the reason that they're moot, even though you're labeling one substantive, one procedural, the reason they're moot is the same, is that there's a new record that will determine whether the claim is valid.
yes, Your Honor.
Can I ask you about the ANILCA claim vis-a-vis?
Yes, please.
I'm sorry?
Yes.
Yeah, vis-a-vis Tongass. So the ANILCA claim is a substantive one because the argument is that there's been a withdrawal, that the roadless rule affected a withdrawal. Let's just talk about it vis-a-vis Tongass for a moment. And so that claim, if the current state of affairs continues and the roadless rule goes back into effect vis-a-vis Tongass, then at least as to that claim, substantively, it's the same.
I think that's right. Yeah, it's essentially. I think Alaska is saying that is the one claim that where Alaska is essentially saying on the face of the restrictions in the roadless rule that it's incompatible with provisions in.
May I interject a question here? I mean, on the face of it, my understanding has always been that a withdrawal means, in public land law, it means it's withdrawn from the public domain and therefore is exempt from statutes like the Homestead Act and the Desert Lands Act and several others that allow individual citizens to come in and claim particular property. Is that right?
That's the way we understand it, Your Honor. And one of the ones that are relevant now to the National Forest is the general mining law of 1872.
Yeah, right. Well, it's a multiple use withdrawal, but the fact is that all of the land in a national forest has been withdrawn.
It's been withdrawn for forest purposes. That's right.
So I've never heard such of a thing, that a withdrawal of a withdrawal. I mean, that's what the way I read Alaska's claim.
Right. I share your confusion, Your Honor, because it is a little bit confusing, because there are existing authorities now under the Federal Land Policy Management Act to withdraw public lands from the public domain. But
so that's a substantive answer to the claim,
Yes.
right? I was just asking about mootness, and so
understood. I was trying to answer Judge Randolph's question.
Yeah, no, of course, and you should, and I have the same question. But just to be clear on where we are in the architecture of the case, that would mean that you get past mootness, and that would be the answer on the substance of the claim. But you're not arguing that the ANILCA claim vis-a-vis the Tongass is moot.
Well, I guess what we're saying is, the ANILCA claim, sure, if that were the only claim in the case, maybe we'd have a different view. But again, the rule doesn't apply, right? So there's a chance that the rule comes back. And the one and the only thing that I can tell that they're concerned with respect to ANILCA withdrawal is the lack of an exception for mineral leasing. Right, and whether mineral leasing actually even falls under the sort of the withdrawal idea is a separate question. But the Forest Service considered in 2001 an exception for road building for mineral leasing and decided not to. But they didn't, close off the inventory roadless areas to leasing. They just said, you can lease, but without new roads.
You can. I thought you could build roads to do mineral exploration.
Yes, you can. And that's what I was trying to say under the general mining law, which is a different issue. That's locatable minerals. And that's, precious minerals, metals. You can do mineral location. You can cut trees as necessary to do it for a surface plan. You can build a road as necessary to provide reasonable access for prospecting and development of locatable minerals. The roadless rule doesn't affect that at all, which is why on the merits, the ANILCA claim, has no basis. But with respect to standing, again, if all the injuries are on the Tongass, roadless rule doesn't apply to the Tongass. If it's going to come back, there has to be a new rulemaking that the courts are going to have to consider. Prudentially, because it's kind of mirrored and tied to all these other claims, it might make sense for the court to hold up on all the claims, right? But if the court wants to decide the ANILCA claim, on the view that there is standing there, we submit there's no merit to the claim for reasons that I've addressed.
Okay, let me make sure that
I thought that the discussion of the merits is useful, even though the chief pointed out that we sort of backed into it via discussion of mootness. But I think those, as the discussion of each of the claims illustrates, the mootness argument does depend a little bit on whether, a purely statutory interpretation facial claim with no record shift, it would seem is less likely to be moot than a claim that depends on, for example, whether one has fulfilled procedural obligations under NEPA. So
that's correct, Your Honor. And we think that the principal claims here, the Tongass specific claims, are clearly record specific types of claims.
Okay, thank you.
I just wanted to ask I guess the sort of predicate question about mootness under our American Bankers case. It's the burden of the movant to establish mootness. It's a heavy burden. When you file the papers regarding mootness, there was nothing on the horizon about a potential new rule rolling back on the 2020 rule, but now there are very definite signs on the horizon about that. And I guess your answer to that is that's all fine and good, but that creates new claims. It doesn't revive the old claims. And that's sort of the message of all this stuff about how record specific the old claims are.
That's essentially correct, Your Honor. And with respect to like the NEPA procedural claims in particular, those clearly are new claims. There's any relief that could have been provided on, with respect to any violation in 2001 has already been provided. You ordinarily just set it aside and send it back to the agency to do it again. The agency's already done it again, in one context, and we'll do it again, in the upcoming rulemaking, proposed rulemaking.
Okay. If my colleagues don't have any additional questions for you, Mr. Smeltzer, we'll hear from Mr. Fine.
Thank you, Your Honor.
Thank you.
Thank you, Your Honors. Ian Fine on behalf of Conservation Interveners. We agree with everything Mr. Smeltzer's just said. Just a couple points I wanted to add. I think Judge Pillard's questioning about this being an appeal from summary judgment is exactly right in terms of the burden of establishing standing by evidence and not just allegations. And I think, in terms of the suggestion of supplemental briefing or even this affidavit that Alaska submitted, I would direct Your Honors to this court's opinion in Swanson Group Manufacturing, which was also an appeal of summary judgment where the court said that it's actually not appropriate to be considering new evidence of standing on appeal from a summary judgment order that was submitted after the judgment was entered. It may be that there would be a case where, for equitable reasons, that was justified. I don't believe that's the case here. Where standing was directly challenged below. Alaska had an opportunity to put in evidence of standing based on the Chugach. It did not. Further, when the mooting event as to the Tongass was something that the state of Alaska initiated with its petition for rulemaking. So I don't, if there were some exception to that rule, I don't think it's been met here. In terms of the questioning about the nature of the ANILCA claim, and whether that is something that should survive. I guess I would point out that there is a flavor of a sort of record-based aspect of this claim as well, in that, they are not arguing that these inventoried roadless areas have actually been like expressly withdrawn. Their argument is more that it's sort of a de facto withdrawal.
Of what? I'm sorry, you just were speaking quickly. This inventory.
Sorry, yes, the roadless rule applies to inventoried roadless areas of the National Forest. And, I don't understand the plaintiffs to be making an argument that these are expressly withdrawn. They're not. I think it's more of a claim that, there's a sort of a de facto withdrawal. It's not withdrawn, Judge Randolph asked some questions about that too, but also, the rule expressly allows for continued mineral leasing in the National Forest. So I understand their argument to be a little bit of that this is a de facto withdrawal, and the facts I think may be relevant to that. For instance, a geothermal lease, a mineral lease, in fact, has been granted in the Tongass on Bell Island under the roadless rule. That's before the court in Exhibit C to our motion for abeyance that was filed in September 2018. It notes that a geothermal lease was granted. So
that affects the nature of the claim that's being made?
Well, I think it may, Your Honor. I mean, their argument is that this has been withdrawn from mineral leasing. The roadless rule withdrew these lands from mineral leasing, and the record would show in a new case that, in fact, mineral leases are continuing to be granted in these areas under the roadless rule. So we agree with Mr. Smeltzer that the court lacks jurisdiction. I'm prepared with the remaining time to discuss the merits if the panel would like that, but if not, then we would submit.
Just circling back on a question that Judge Randolph had asked and that USDA had responded to. So is the ultimate position that there's no withdrawal, or just that there's no withdrawal affected by the roadless rule? Because as Judge Randolph pointed out, a national forest is categorically withdrawn or not.
Your Honor, those are threshold. The claim fails for, I think, an even easier reason, which is the one I was discussing, which is, even if one could have a withdrawal from a national forest, a withdrawal means to exempt from the operation of the public land laws, and the roadless rule does not exempt any lands from the mineral leasing laws. The mineral leasing laws still apply. With this example of this geothermal lease that was granted in Bell Island. So I think the claim fails for an even more fundamental reason than that. It's essentially
for a narrower reason, I guess. It's just saying more specifically, withdrawn or not, the roadless rule doesn't withdraw these lands from the only type of use, use that they've identified.
That's correct, Your Honor. Yeah, I mean, as Mr. Smeltzer discussed, the general mining law still applies. Access for mining is still allowed, and the roadless rule also does not withdraw from mineral leasing, which is, yes, Your Honor, as you suggested, the one type of use that plaintiffs have pointed to in support of their ANILCO argument. So unless there are no further questions, Your Honor, we agree that either the court should dismiss for lack of jurisdiction, or to the extent it has jurisdiction, it should affirm the judgment below.
Thank you, Mr. Fine. Ms. Gramling, we'll give you back your 3 minutes for rebuttal.
Thank you, Your Honor. So to address the receipts issue, the state's position is that as far as timber receipts from they're not limited to timber receipts. The state receives various types of mineral sharing and revenue sharing from national forests. Timber is just one aspect of that. And the roadless rule generally prohibits road construction and timber harvest, and there are serious developmental consequences to that. And so the roadless rule limits activities of the Tongass, and that has a negative impact on the receipts that Alaska could receive. Secondly, Alaska, we believed that our standing is self-evident based on the allegations in our complaint and our comments in the record. And, we would certainly be happy to provide new information, but we could also do supplemental briefing on the documents that are already in the record as well.
What in your comments to the record are you referring to? Because I do think that, there's a hurdle, as Mr. Fine pointed out, to when the summary judgment record was ruled on below on appeal, inviting new information. But I think it's quite a different question whether the information is there, but just hasn't been really identified, given that it wasn't as much of a sort of pointed focus at an earlier stage. So you keep mentioning the comments of Alaska as containing information that would establish the harm that the roadless rule causes to the state in the Chugach. And is there any citation you'd want to give us on that?
So the comments in the record that I'm referring to are the state's comments as part of the roadless rule process. And so the state in the rulemaking made comments at various stages. And so
specific in that you'd want us to look at.
I don't have anything specific off the top of my head for you, but the state did make substantial comments, and a large portion of those comments were statewide claims, not just Tongass specific claims. The injuries are more acute in the Tongass, certainly, but that doesn't mean that they're non-existent in the Chugach, particularly when the roadless rule applies to nearly 99% of the Chugach. So, the Chugach is extremely restricted, and it is a very large forest in Alaska. And then also turning to the substance of the ANILCA claims real quickly, the state's position is that while withdrawal in other statutes does have the definitions suggested by the government, this brings us back to Sturgeon in that Alaska is different, and the withdrawal provision in ANILCA needs to be construed in accordance with the broader balance of purpose in ANILCA and then other sections of that same statute. And so what was Congress concerned about? Well, Congress was concerned about quasi wilderness and conservation units being established by the federal government, because that was what Alaska was protesting. And the Mountain Legal States case shows that mineral leasing, could be a withdrawal. And that case is very poignant from an ANILCA standpoint, because it was at the same time and with the same secretaries that were at issue during the Carter administration, right before ANILCA was enacted. And so those were the sorts of withdrawals that were concerned. And so my time is up. So there's not any additional questions. The state requests that the roadless rule be vacated. Thank you.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 20-1324, Keryn Newman and Allison Heberty, petitioners, versus Federal Energy Regulatory Commission. Ms. Newman for the petitioner Keryn Newman, Ms. Heberty for the petitioner Allison Heberty, Mr. Fish for the respondent, Mr. Gossett for the intervener.
Good morning, Ms. Newman. Please proceed when you're ready.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. I am Keryn Newman, and with me this morning is Allison Heberty. We are PJM ratepayers appearing before the court pro se. This morning, I will address past expenditures to influence public officials, as well as account 426.4 and rate making. Ms. Heberty will address past advertising expenditures, including the formula rate mechanisms that will allow for their recovery. We would like to reserve 2 minutes for rebuttal. This case is not about whether the commission can change its mind on rehearing. Of course it can. This case is about the arbitrary and capricious way the commission failed to logically and reasonably support its decision to reverse course on the recovery of past expenditures to influence public officials. A formula rate prevents a utility from utilizing excessive discretion in determining the ultimate amounts charged to customers. PATH, and then later the Commission on Rehearing, utilized excessive discretion by misinterpreting account 426.4 and misinterpreting PATH's formula rate in order to increase the charges to customers. The Commission's uniform system of accounts is a regulation that sorts utilities' expenditures by their purpose. All expenditures for the purpose of influencing belong in account 426.4. The first clause covers the influencing of public opinion. The second clause covers the influencing of public officials. Common to them both is the act of influencing. Interpreting this account so narrowly that influencing expenditures are excluded defeats the purpose of the regulation. When the commission sets rates, it may include amounts segregated in account 426.4 in the rate. However, that's not what the commission did when it set pass rate. In that instance, the commission specifically excluded account 426.4 from the rate. Pass annual formula rate update filings cannot change the rate. They are not a rate-making proceeding. Instead, the commission must make an accounting determination to find the proper account for an expenditure whose classification has been challenged. Choosing at this point to place an expenditure in an inappropriate account simply to make it recoverable circumvents the limitations of the approved formula rate. The commission has no discretion to alter or adjust a rate retroactively. However, the commission altered pass rate when it made a retroactive recoverability determination to change the accounting classification of expenditures that were prohibited by the rate on file. A recoverability determination is only properly made when the commission is setting a rate. The commission set pass rate back in 2008, and thereafter it's a formula rate dependent upon accounting assignments. Past formula rate protocols that were included in our opening brief addendum at page A9 state that an annual update shall be in accordance with the commission's uniform system of accounts. There's nothing in there about making retroactive recoverability determinations, because making a recoverability determination at that point retroactively alters the rate on file.
So Ms. Newman, it seems like your argument really boils down to the plain language of the account of 426.4, and perhaps most simply and clearly clause 2, which includes in that account expenditures for the purpose of influencing the decisions of public officials. And as I gather, there is no dispute that these expenditures were for the purpose of influencing the decisions of public officials, but that FERC and the intervener argue that that purpose was effectuated in an indirect manner, and that we should read this clause to put into account 426.4 only expenditures for the purpose of directly influencing the decisions of public officials. Is that an accurate encapsulation of sort of your core argument?
Yes, the unwritten direct versus indirect influence test that FERC added in there is just doesn't make sense. The commission did not cogently define the line between direct and indirect. I mean, there is no difference between a professional lobbyist versus a citizen lobbyist. Both individuals are directly appealing to the public officials.
Can I ask, do you think there's a, oh, go ahead, Judge Baylor, I'm sorry.
No, please go ahead.
Do you think there's a difference between influencing public opinion and influencing public officials?
The way it's written in the account, the first clause about influencing public opinion is kind of related to situations where the public actually can take the action that the utility is trying to influence, like an election or pushing an elected official to do something, or a referendum, things like that. That's where the utility would influence the public opinion to get what it wants. But in the second clause, they're influencing public officials. This is the situation where only the public official himself can make the decision. And they were trying to influence the state utility commissioners to approve their project. And, but they say, no, we were just influencing public opinion. But it makes no sense to spend $6 million trying to influence public opinion if PATH did not also intend for the public opinion that it influenced to, in turn, influence the public officials to approve their project.
Well, is that right? I mean, I trust there are monies that power companies or transmission companies spend for general goodwill. They might, I don't know, want to encourage people to, buy plug-in vehicles rather than fossil fuel vehicles, and just make people feel warm and fuzzy about about the grid and spend money on that. I mean, that would be for public opinion that wasn't instrumentally related to a decision. And that
Correct.
does that not exist? Is that just a fanciful
No,
category?
I think that does exist. And I mean, that's something a utility would do in its normal course. But here, the whole goal of PATH was to get this project approved. If PATH could get this project approved by the state regulators, the parent companies, American Electric Power and First Energy, stood to make an enormous profit from building and owning this project over its expected 40-year life. At the time they chose to influence public officials, PATH was looking at a 14.3% annual return on its 50% equity stake in this $2.1 billion project. There was a lot of money riding on the state approvals, not just grid reliability for ratepayers.
I ask you a question about the fact that the project's been canceled. And so PATH is really an empty shell, I guess. And there's, how does PATH, well, PATH doesn't have a rate now, does it?
Yes, it still has the same formula rate that it was.
It does, but it's never going to be out. It doesn't have any customers, does it?
Well, PJM ratepayers are responsible for all the costs in the formula rate. So in this case, if PATH can recover the $13.2 million back from ratepayers, it'll come from everyone's pocket in the PJM
Well,
region.
isn't that up to the, the wholesale rate, I understand, but the retail rate, which is what I take you pay, is totally up, not totally, but it's up to the state utility commission, isn't it?
Well, the state utility commission has to pass through these rates that are set by FERC without touching them. It cannot alter these rates and leave PATH stranded, even though, FERC says this is, the transmission rate is a federal process, whereas the distribution rates are a state process, and the state must pass.
So how much more in your monthly bill is going to result from FERC's action here?
It's really hard to determine.
But don't you have to determine that in order to establish standing? And let me just follow a follow-up question. I mean, if it's 1 cent a month, then I don't know if there's a de minimis requirement in standing, but it doesn't seem to me to be any kind of concrete injury. So what is your concrete injury?
Well, any ratepayer has standing to challenge the rate that is set at FERC, and there is no other venue for us to challenge this rate. So whether it's a penny or $25, we can't, FERC cannot shut us out. And actually, this issue came up in the case a number of times, and the commission found in our favor that we did have standing, and neither party has questioned our standing in this case.
Well, I know that, but you don't have to have standing to appear before FERC.
So the standing that's being asserted is the standing as ratepayers who are affected by what is authorized to be passed through.
Mm-hmm.
Yeah. I think it was asserted in the briefing that this formula rate is a typical kind of formula rate, and this is really more a question for FERC. But do you have reason to believe that the way that the items that are in and out of this rate are also appear in other transmission formulas?
Yes, they are all pretty similar. There is one exception with the advertising provisions where some of them are slightly different, and Ms. Heberty, that's more in her wheelhouse, so I will let her explain that.
And if we were to agree with you that the reconsideration opinions were contrary to the plain text of the account, we don't need to reach the separate questions about whether these expenses could be appropriately put into the other accounts, the advertising and the 900 series accounts, right?
Yeah,
because those are residual, those are framed as only if they aren't appropriately in another account. So if they were appropriately in 426.4, those accounts wouldn't come into play.
Exactly. Before you put something in account 923, which is kind of a general account, you have to first make sure that it doesn't fit in a more appropriate account. And I mean, some of these accounts can apply to different expenses, and maybe a certain expense could be in two lists and two different accounts. So you really have to look at what the account language says. And so when you have these kind of influencing expenditures, the first place to look is account 426.4. And only if it does not fit there, then you can put it in 923 or some other account.
Okay. Thank you, Ms. Newman. Unless my colleagues have further questions for you this time, we'll hear from Ms. Harvey.
Heberty, I believe.
Heberty, sorry. My Zoom moniker is blurred out. Heberty.
No problem. I've been called worse. Good morning, Your Honors. PATH's advertising belongs in 426.4 because advertising account 930.1, there's a note B in the Uniform System of Accounts plain language, and it reads, exclude from advertising account 930.1 and include in 426.4 expenses for advertising activities which are designed to solicit public support or the support of public officials in matters of a political nature. The standard definition of political being relating to government or public affairs of a country. FERC acknowledges, as you've stated before, the advertising is intended to solicit support for approvals needed from state governmental bodies. And so those expenses do rightly belong in account 426.4. Our subsequent argument is that past advertising belongs in the other ad column of attachment 4 of the formula rate. Via the formula rate, any expense placed in 930.1 is first and foremost other ad. And that those expenses would be described, as you were saying, the goodwill, institutional nature, and I believe those words are actually used in the 930.1 descriptor. But those expenses are, any expense in 930.1 is first and foremost in a broad category of other advertising. The exceptions, which are listed in various ways in the PATH company's formula rates, are similar to numerous other FERC-regulated utility companies shown in the, we had a non-exhaustive spreadsheet in our brief at JA 573, 574. FERC's orders on rehearing are the first instance in the record of the advertising being solely and completely outreach. FERC did not point to any evidence in the record when it determined the advertising to be outreach. So characterizing all of the expenses as outreach, I believe, is a reach or arbitrary and capricious. The PATH companies themselves did not maintain their books to reflect any sub-accounts for 930.1. They simply placed the balance of 930.1 into the column of the formula rate, which made the entire balance the responsibility of ratepayers, instead of categorizing using definitions, descriptors, something to characterize these expenses in the different ways that the formula rate does. This arbitrary and capricious act was followed by FERC's own arbitrary and capricious act in their opinions on rehearing, where they basically did the self-same thing. The 2020 commission went so far as to change the wording of the column header that they chose to focus on. The heading reads, safety, comma, education, comma, citing and outreach related. The opinions read safety, comma, education, comma, citing, comma, or outreach in their determination. A change from and to or, well, it might seem small, as well as the addition of an Oxford comma drastically changes and amounts to the changing of the formula rate retroactively, something that cannot be done without a rate making proceeding, and ignores the plain language used in several other places of the formula rate, in which safety related advertising is read to be the key determining factor. Finding all advertising is outreach further nullifies the exceptions and therefore allows for the overcollection from ratepayers. And that the formula rate so obviously is aimed at avoiding in 930.1. We ask the court to vacate opinions 554A and 554B and remand to the commission for further proceedings with instructions to please follow the initial decision and opinion 554.
Can I ask you one question, which is if we, you have your point that the way that the tariff in the table retitles using the Oxford comma or not using the Oxford comma, I can't remember which way it goes, but switching it was problematic and should have been done in another way. But suppose just for as a matter of hypothesis that we don't agree with you on that, and we take that second way of describing the list as a given, do you take issue with whether the expenses were appropriately allocated to that account if we take that revised way of characterizing it as a given?
So the account is a general advertising account. What happens in the formula rate is where they're listing exceptions, which are then recoverable, because it's understood that all advertising is not the responsibility of the ratepayers. It is the responsibility of the utilities. And so if the expenses are in 930.1, the exceptions are very specifically focused on safety related or citing related, because we understand and we did not challenge expenses, say advertising for open houses that were going to be held or public meetings that were going to be held. Those kind of advertising expenses we did not challenge, and because we do recognize that the precedent is there for those particular expenses to be recoverable. So we did not challenge those.
Just to be clear, and I think this is clear in your briefing, that this whole categorization is only relevant if these expenditures aren't appropriately in account for 26.4.
Exactly.
This is an alternative argument.
Yes. Yes. But our primary argument is that they do rightly belong in 426.4, along with the actual outreach. I know there was some discussion, or there was some the word outreach is used in the contracts of the subcontractors, and so trying to conflate the outreach that Ms. Newman is more focused on, as opposed to the outreach was not advertising. It was not specified to be outreach. There was not until what was it, was it 554A? It was the first time they mentioned that this was outreach. It came out of nowhere. And so it kind of adds to the arbitrary and capricious way that it seems to be that FERC is addressing these at this point, to more look at retroactively recovering, as opposed to following the process of placing the expenses in the correct accounting accounts first, and then letting basically the chips fall where they may as far as the formula rate goes. Otherwise, we're doing it backwards.
Is it your view that we should look, or FERC should have looked at 426 without regard to 930.1? And then if it finds that the expenses were fit within 426, it doesn't have to decide whether they're political or not?
If they're political or not, I'm sorry, Your Honor, I don't understand that last part of the question. Could you repeat that? I'm sorry.
We look at, or you have FERC look at 426 and concludes that the advertising was for the purpose of influencing public officials, right? And so it's FERC, does FERC then have to also look to 930.1 to make sure that that fits within the definition of what of political?
Well, I think actually it goes maybe the other way, that if that it's that the advertising, if they wanted to put it in 930.1, but there is the note B, which says this probably is not the account for these particular expenses. You need to go, these need to more properly be placed in 426.4, and they do fit within the descriptor of 426.4. So I'm not sure that determination.
Well, you came up with a definition of political that says that it's influencing a public official, which makes the meshes 930 and 426 together. Where did you get that definition of political?
That the influencing, well, it says the note B was, which it says note B of 930.1 is, I think, what you're maybe referring to as what, so 426.4 include in 426.4 expenses for advertising activities which are designed to solicit public support or the support of public officials in matters of a political nature. That's note B of account 930.1.
I know
in the US of A.
My question is, where did you get your definition of what is of a political nature?
I just pulled my definition of political from the standard definition of, just any dictionary, I guess. You mean when I referred to it being approvals and solicit support, let's see, relating to government or the affairs of the country? Is that what you're referring to as my definition?
Right.
Well, one of the path or the witnesses also referred to political opposition when they were talking about the approval process. That so.
I guess one question I'm not sure that I'm following. And he can speak to it directly, what my colleague is asking, but part of the question might be, does political refer to, is that a shorthand for everything that's covered by 426.4, or does it contain its own potentially limiting meaning that might be read back into and provide sort of a gloss on what is included in account 426.4. Again, apologies to anybody who I might be further confusing rather than illuminating.
I think so. The when 426.4 was basically so there was order 276 that may help us get to an answer on this one. Let me see. JA 290 is where some of the language that was used in making sure that we understood what was supposed to be in 426.4. And it actually talks about advertising in mass communications media to influence general public or public officials. It says such advertising, even where it has no specific or express objective, is calculated to affect public or official attitudes towards future legislative or administrative action. I think the word political is I believe, just understanding that it's not, that it is having to do with regulation, governmental bodies, influencing those decisions made at that level.
Okay. Let me make sure my colleagues don't have additional questions for you, Ms. Heberty. Thank you. We'll hear from the government, Mr. Fish.
Morning, Your Honors. May it please the court, Jared Fish for the commission. I'd like to pick up on the question posed by Judges Randolph and Pillard regarding what is the definition of political, because this really contextualizes this entire case. The commission reasonably found expressly paragraphs 84, 86, and 99 of opinion 554A, that's JA 508, 513, that the disputed expenses here are not political. And it explained why. It explained that the expenses here were incurred for a public benefit because PJM determined there was a reliability need, and this project would meet that public or serve that public benefit. And that follows from how the commission has previously defined political versus non-political. In the Alaskan Northwest case, which petitioners cite, and we also cite in note 43 of opinion 554B, the commission explained there that political expenditures, quote, have a doubtful relationship to rendering utility service. And there, the commission found that the disputed expenses did have to be recorded to account 426.4 and were not recoverable because the applicant had, quote, not adequately demonstrated what benefits, if any, have or will accrue to ratepayers. That's at page 61, 428 to 29 of the Alaskan Northwest order on show cause order. That's an important distinction because it also gets to the fundamental error committed by the ALJ and the commission initially in opinion 554. Both the ALJ and the commission initially compared this case to the Alaskan Northwest cases in finding that both involved expenses incurred prior to the selection of the project at issue. Here, however, the project had not been selected. There, it was by Congress that ultimately chose the natural gas project. Here, the project was selected. In fact, PJM actually ordered the construction of the line. And
it wasn't really in the sense that it wasn't, and in the end, couldn't go online because it didn't have certificates of public convenience and necessity. So this is not a situation where there's benefit to the ratepayers from the action, because in fact, the ratepayers never benefited from this.
Well, I respectfully disagree, Your Honor. Ratepayers did not benefit because the line was ultimately not built because PJM determined in 2012 there was no longer a reliability need. But the question of public interest is a federal question. We're talking about a FERC regulated utility under FERC accounting regulations concerning expenses incurred by a FERC regulated utility PJM. And there's nothing in the accounting regulations, commission precedent, or judicial precedent that subordinates a federal determination of need to a state PUC's determination under its own policies, under its own laws. So and furthermore, I don't think there's any argument that the state PUC proceedings on the certificates of public convenience and necessity had anything to do with selecting a project. It was just whether they could, under state law, block the project. So that distinguishes these cases and takes it out of the realm of a political expense. Order 276, the preamble to account 426.4 explains, and I'm going to reference our addendum at page 29, that 426.4 is all about expenditures for political purposes. So the commission's reasonable determination that these are outreach rather than political because they were incurred pursuant to an RTO ordered project to meet a public need takes it out of the realm of 426.4.
Does it matter, Mr. Fish, that was not an argument ever raised by PATH before the commission. That's an argument that FERC has developed in the rehearings.
No, Your Honor, because perhaps if PATH was challenging the commission's determinations on judicial review, but what the court is reviewing here is the commission's final order under 16 USC 825L, and it's looking at what the commission ultimately decided. We could argue if PATH was challenging us and they raised a new argument that they hadn't raised in the rehearing request, that then that argument was waived, but that's not the case here.
So may I ask you, suppose that it's conceded that particular advertising is for the purpose of influencing the state's utility commissioners. What account does that go into?
Well, it depends on whether the influence was direct or indirect, Your Honor. And here's where the commission drew a reasonable line for which we deserve deference. It distinguished the expenses, the direct lobbying expenses incurred by access point.
Well, it's advertising. It's on television. It's on the radio. And, you know, get to your local state commissioner and tell them we really want this transmission project. That's the advertising. Now, where does the expense of that advertising go? Does it go to 426 or 930?
Your Honor, it would depend on whether that advertising is directly in front of the public officials. And here there's no evidence it was. The ALJ at JA 328 explained that the promotional brochures.
It's aimed at both. It's aimed at both. It's aimed at the public official and it's aimed at the public. Where's it go?
Well, in your hypothetical, if it's directly, I would say that the pamphlet has to be handed to a public official, not just a member of the public. Because if it's one step removed and it's handed to the member of the public, then the hope is that member of the public is going to try to write letters to their public utility commissioner or do something else to directly influence. And that takes it away from the expense incurred here, which is only to influence members of the public. But the record shows that the only advertising here was to quote, this is from the ALJ's decision, J328, to extol the need for reliability and why the project should be built. And he references advertising that was promotional in nature. There's nothing there that ties that advertising to direct contact with public officials.
Well, not direct, but page 66, I think it is, of your brief, and plus page 67 is essentially an admission that the very purpose of the advertising was to put pressure on public officials.
Ultimately, to put pressure on public officials, but that's the nature of advertising. At some level, advertising is intended to persuade.
What's the rationale if a group of public relations people goes to the staff of a utility commissioner and wines and dines and gets them to agree to the project, as opposed to going directly to the public utility commissioner himself or herself? What's the rationale for saying one is not recoverable and the other is?
Well, Your Honor, I'd say there is no distinction there because you're talking about, you said staff, you're talking about staff who presumably are incurring an expense to lobby, to wine and dine the public official. So in either of those cases, it's more like Access Point and Larry Puccio, where there's an expense that's actually tied to the activity before a public official. That's what's missing with the ALJ's conclusion that all the expenses have as their ultimate goal.
So can I ask this question? I mean, the line between direct and indirect when you're dealing with public officials can be a little bit elusive, as some of the questions might be elucidating. But just under the text of the regulation, it's puzzling to me. 426.4, it says this account shall include expenditures for the purpose of influencing public opinion with respect to, and then there's a bunch of stuff that follows with respect to, including approval, modification, or revocation of franchises. And that's all part of clause 1, right? And
yes,
is the proper way to read that approval, modification, or revocation comes after for the purpose of? Or is it for, or it comes after, I'm sorry, Does it modify for the purpose of, or does it modify for the purpose of influencing public officials with respect to approval?
Well, public opinion, Your Honor. So
I'm sorry, public opinion in clause 1. Yeah, right. Public opinion. Is it for the purpose of influencing public opinion with respect to approval, modification, or revocation of franchises?
Yes, Your Honor. That's and so if
then
if
the
case,
text kind of I don't know that the distinction, at least as an intuitive matter, makes a lot of sense, but the text talks about influencing public opinion with respect to approval or revocation of franchises. And I take it is it public officials who determine whether to approve or revoke franchises?
Correct, Your Honor.
So the text itself is kind of contemplating some distinction, apparently, that seems not entirely apparent as a matter of how we normally intuit these processes working. But this is talking about influencing public opinion with respect to revocation or approval of franchises, which is necessarily something that goes through public officials. And then the next clause talks about for the purpose of influencing the decisions of public officials.
Right. Well, as a first matter, Your Honor, I'd say what all this boils down to is that regulation is certainly ambiguous, and we receive discretion for a reasonable interpretation. But franchise, I think the point here is everything goes to whether the influence of public opinion was on one of the listed items in clause 1. If it is, the relevance of the fact that everything goes towards influencing public officials in the end, it supports our textual argument.
Well, can I ask this? Is the approval of a franchise a decision of a public official?
Yes. Yes, Your Honor.
Right. So
but we're not talking about franchises here.
I know we're not. No, I think I don't think this question is meant to be hostile to you. Actually, it's just meant to raise a question, which is the first clause presupposes that you can influence public opinions with respect to decisions of public officials, because it's talking about influencing public opinion with respect to the approval of a franchise, and that's the decision of a public official. But then the second clause talks about decisions of public officials.
I see where you're getting. I apologize, Your Honor. Yes. So to give the two independent meaning, we'd have to read them. It makes sense to read them separately. I think that
maybe it's just at least seems to raise that. It's at least potentially seems to raise that question in my mind, even though just as a matter of the way we normally think about things, for a lot of the reasons, the questions that you've been faced with presuppose, we always think about influencing public officials through the medium of influencing public opinion. That just seems natural to think about things that way.
Right, exactly. And so if you could do that with certificates of public convenience and necessity, it takes the list out of clause 1 and it renders it superfluous, because you could seek to influence public opinion on any matter, and it would still fall under clause 2, even if it wasn't directed at one of the items in listed in clause 1.
Well, but what about goodwill advertising generally, where you're trying to influence public opinion to be more comfortable with what you're doing in the world?
Right, Your Honor, and that would be an appropriate. It would be appropriate to record those expenses to account 930.1 pursuant to Note A.
Why wouldn't they fall within clause 1 of 426.4?
Well, again, because here we're talking about certificates, not for franchises. That would be a different question if we were talking about seeking to influence public opinion on the matter of franchises.
No, I'm just talking about the statute. And I guess let me back up and ask you. Your brief talks a lot about deference, but as we know, deference is only owed where the text is, applying all tools of statutory construction, the text is ambiguous. Your argument as to why the text is ambiguous as to whether direct is implicit is what?
Well, the text is ambiguous because if you don't read it as applying to only expenses that have an indirect connection to influencing public officials' decisions, then the list of items in clause 1 falls out of the account. It's rendered superfluous. Clause 1 is subsumed under clause 2 because, as Chief Judge Srinivasan said, as we normally think about it, any attempt to influence public opinion has as its ultimate goal influencing the decisions of public officials. So if you can—
Does it? That was why I was asking about influencing public opinion for purposes that don't have to do with influencing public officials, influencing public opinion so that people will be more inclined to come and work for you. People will feel more cooperative at an eminent domain proceeding when a power line is going to go over their property. Or, I mean, there's a lot of reasons to want to influence public opinion.
Yes, Your Honor, so taking that as the case, then that further supports our position, because then the ultimate goal is not to influence public officials' decisions. So all you're left with is an attempt to influence public opinion on the matter of certificates of public convenience and necessity, which are not included in Clause 1. And, you know, even if you found that Clause 2 could apply to indirect influences of public officials, under your example, Your Honor, there's no attempt to influence public officials, so the expense just wouldn't be recorded to account 426.4. So I think under either interpretation, we get to the same place.
What is the rationale for saying that you put in the 426 account expenditures for to influence public opinion with respect to the franchise granting of, but you don't put it in if it's with respect to the granting of a certificate?
Well, Your Honor, that's something we explain at paragraph 19 of opinion 554B, where the commission explains that, and this gets back to the point of whether these are political expenses or outreach expenses. Seeking a franchise is seeking a lucrative status for the utility itself. It's not imbued with the same public interest, or at least it's not necessarily imbued with the same public interest. A certificate of public convenience and necessity, by definition, is all about the public need for the project. And the commission in its regulations has distinguished the two terms. Account 302 uses the two terms separately. And so it's a foundational tenet of regulatory interpretation that where the commission uses the same term in two different provisions, it should be given the same meaning. So if franchise is exclusive of certificates account 302, it should also be exclusive of franchises in account 426.4. And the commission's own precedent going way back has distinguished the process of seeking a franchise from the process of seeking a certificate. I can't speak, Your Honor, exactly why the commission, when it wrote the regulation back in 1963, decided to include franchises in the list and not certificates, but that's a plain text issue. I mean,
So because you represent FERC, I had a question about that's really parallel to Judge Randolph's question about the rationale, and I appreciate your answer pointing to paragraph 19 of 544B. But there also seems like there's some historical part of this is you know, when 524, I'm sorry, when 426.4 was written, were certificates of public convenience and necessity playing the same role that they play now in the sort of de-integrated electricity field?
I don't know the answer to that question, Your Honor. I can say I know that several of our precedents that distinguish franchises from certificates go back several decades, you know, before the advent of RTOs and organized markets. So I do think the distinction holds. And
I agree with you that in a way it doesn't matter because we're going on plain language, but what is a franchise? I mean, one of the things I've noticed is even in the record in this case, sometimes franchise is used in a kind of casual way, meaning, you know, you got the business, meaning synonymous really with a certificate of public convenience and necessity or other choice of your firm to do the work. But is there a more technical way in which the commission uses the term in contemporary approvals?
Well, Your Honor, whether you have a franchise determines whether you get to provide service to a set of customers. And that's qualitatively different from a certificate, which says you can build this line. You can go ahead and break ground on this project. We find that it's needed in the public interest. And
you said whether you have a franchise determines whether you get to provide service to a group of customers. Where is that definition offered?
Well, it's at least implied by paragraph 19, where, let's see.
No, I mean in statute or regulation.
Well, I could refer back to our brief in looking at examples in the past where the commission has distinguished the two. Apologize, just give me a moment. So on page 28 of our brief, so Illinois Public Service Company, this is 1966. So we are going back a long time where the commission has distinguished the two. A natural gas company received franchises for the right to deliver gas to those towns. And later it received a certificate of public convenience and necessity authorizing it to commence the service. So the first was a competitive, presumably a competitive bid, winning the right perhaps because it could provide service at a lower rate. And the second certificate was a finding, was an authorization that that service could actually go forward. And that's also reflected in Algonquin Gas Transmission Company and Trunkline Gas Company. I don't know that I can give a completely satisfactory answer to your question, Your Honor, because the past precedent is somewhat limited, and I don't have at the ready a precise definition that we've offered beyond what we have in the record here.
Can a franchise be, you're sort of drawing a distinction, it seems like, between public spirited and private spirited. And it seems like really a lot of your argument is animated by this distinction that you see, that the purpose of 426.4 is to render certain things off limits for purposes of passing on to the ratepayers, and that would be private spirited things. And then the residual stuff that can go into 930 and 923 is public spirited stuff that can be fairly passed on to ratepayers. That's sort of a large measure of the underlying logic here. And what I'm wondering is, for franchises, which are specifically denominated in 426.4 and therefore would be off limits for passing on to ratepayers, are the franchises that are publicly spirited. So it actually makes sense to pass on the associated costs to.
I mean, I understand your question, Your Honor. Why you're saying that franchises would be publicly spirited?
Well, I guess what I'm saying is, it seems like part of the distinction you're drawing between franchises and certificates, at least with the certificate in this case, is that the certificate in this case has this imprimatur that it pertains to the public in a way that it makes sense to pass on the associated costs to ratepayers. Whereas a franchise wouldn't necessarily do that, because it could be just for the private gain of the entity that's requesting the franchise. And what I'm asking, I think that's part of the logic of your submission, and it seems to be in paragraph 19 and some of the other places in 554 and 554A and B. And what I'm asking is, are there franchises that overlap with certificates in this way, and that the franchise actually would be perceived as doing something that would be public facing in a way that it would make sense to pass on the associated cost to ratepayers?
Yes, Your Honor, there could be. And I think this points to an important distinction that this court highlighted in its 2008 Braintree decision. Account 426.4 in and of itself does not bar passing expenses recorded there through to ratepayers.
But it sounds like for most formula rates, 426.4 is not included.
Here, that's true, yes. But
is that not generally true for formula rates?
No, and that's why this case is a bit sui generis, and why the court, we don't have an opinion directly relating to what the circumstances here, where it's just a straight accounting determination. In Braintree, the court didn't even need to decide whether the expenses, which included lobbying there, had to be recorded to 426.4 at all, because it found ultimately, because 426.4 was included in that formula rate, the costs were properly passed through to ratepayers because they were all imbued with a public interest. They all had to do with an RTO objective. And here we have the same situation. All these expenses, the expenses incurred, serve an RTO objective of reliability. So yes, I would, I
thought there was a stated rate, not a formula rate in ISO New England. You said it was okay under the formula rate.
I apologize, Your Honor. If it shouldn't make a difference though whether it's a stated rate or a formula rate.
Right. I mean, the point was it wasn't excluded there, so that wasn't the question. The question was, is it compelled speech, or there were other issues, there. So the question is sidestepped, but I guess the underlying question is, the chief said that for formula rates, it seems that 426.4 is often excluded, and I'm interested, is that not the case? Because you seem to be pushing back on that.
I don't know the answer to that question. That's not exactly in the record. To the extent that petitioners argue that this is an odd formula rate, they do so only in their reply brief, and that argument I respectfully submit is waived. But it should
wait. You don't know whether this formula rate is typical or unusual, I'm sorry. Let me make it a more specific question. Whether excluding recovery for amounts appropriately in account 426.4 is typical or not. It's not something that you know.
That's not something that I know beyond the precedent of this court. And in Braintree, the court said it doesn't matter. It doesn't matter if it's recorded to 426.4 or not, because
in that kind of rate, if it's a stated rate, but I think the question is a question about the broader importance of the decision in this case. Mm-hmm. Is this a very exotic formula rate, a one-off, or do most formula rates allow recovery under other accounts, but not passing through to ratepayers amounts that are appropriately described by 426.4?
And I don't have the answer to that
question. You have no idea.
I'm happy to look into it. All I know is the precedent that we have with the commission and this court, which has not had to resolve this issue. So I agree that the issue is important for broader purposes. But I think at the end of the day, whether excluding 426.4 from formula rates is typical or not, the question ultimately boils down to what is a proper accounting determination? What does the text of 426.4 reasonably accommodate? And here we're talking about, petitioners point to no evidence to suggest that the certificates applied for in the 3 states somehow fall under the definition of franchise in account 426.4 for federal purposes. There's no evidence to suggest that. So we have to take the certificates as they're named in the states on their face as distinct from franchises, which are covered in clause 1 of 426.4. And as for, I think we've gone around this a couple times in a couple different ways, in ways that reinforce our interpretation of clause 2 as applying only to expenditures with a direct connection to influencing public officials. And again, the commission drew a reasonable distinction here. It didn't say that all the disputed expenses can be recovered from ratepayers. It said those by Access Point and Larry Puccio, where there was evidence of an expense tied to direct lobbying of public officials, those had to be recorded to 426.4, and those expenses are not at issue here. Path didn't dispute that finding. All we're left with are the expenses that are tied to Path's contractors seeking to influence public opinion, and those expenses stop at the water's edge of the public. There is nothing in the record.
Let me make sure my colleagues don't have additional questions for you, Mr. Fish.
Thank you, Your Honors. We request you deny the petition for review.
Thank you, Mr. Fish. We'll hear from intervener, Mr. Gossett.
Sorry, trying to unmute. Thank you, Your Honor. Chief Judge Srinivasan, and may it please the court. I think now may be a good time to take a small step back and focus on what this case is basically about, which is whether Path can recover what are ordinary expenses that in the development of a project like this that was ordered by PJM and approved by FERC. To be sure, to develop these transmission lines, Path had to play in the court of public opinion. But the evidence is that that was normal and necessary and in no way makes the expenses unrecoverable. That's the point of this court's Braintree decision, which said that it can be recovered and affirmed the commission not even deciding if certain expenses were in 426.4.
Can I just stop you, Mr. Gossett? You and Mr. Fish have referred to this as ordered by PJM. Presumably Path applies for this. I mean, this is not a hijacking of a private company out of the blue, right? This is something that PATH wants to do as a business matter and gets the job from the ISO.
Sorry, Your Honor, I didn't mean to talk over you. That's not my understanding. My understanding is that the way this works is that PJM, the RTO, determines that there is a reliability problem, that there was a problem with adequate electricity in the sort of DC, Baltimore area, and then went about figuring out how to solve that reliability problem and chose this project and then designated specific entities to construct the project. It is, of course, the case that those entities were interested in the project, but they did not, but the determination was made by PJM, not by PATH, and PATH didn't create the project and bring it to PJM in the first instance. It goes the other way around.
It's really helpful. But PATH applies, or does PJM kind of look out and say, who's best for this? I'm going to hire PATH to do it. Who approaches who? My understanding was that PJM determines there's a reliability problem, and then PATH says, hey, actually joins some pieces together and says, hey, we're interested in that.
I'm not sure the exact order. I mean, I think it's a discussion at that point. Obviously, these were the two companies that created PATH, its own company, were the two primary transmission owners in the region. So it's unsurprising that they would have been selected to do it, but it wasn't the case that they were the initiator of the project, if that makes sense.
Right, no, because this is under an ISO, of course. But it struck me as a little odd to say the project is ordered by PJM when it's a business venture that PATH is voluntarily entering into.
I don't actually think in the end it counts as voluntary. I believe that once PJM instructs them to make the project, it is no longer voluntary on their part under the PJM governing documents. They have been instructed to take all efforts to make the project in the interest of all of the PJM customers in a 13-state region. It's not specifically that they are now choosing to work on it. They can't just stop working on it because they've been told to make the project and told to use their best efforts to doing so. And that's why I point out that the evidence in the record is clear that these sorts of expenses are normal in that sort of project. I mean, that's Mr.
So once they've agreed, it may be that they have obligations to continue, but I'm sorry. This is not a business venture that PATH voluntarily entered into? Your response was about, once PJM had instructed them to proceed, they had to proceed. Of course, they're under an obligation. But and this matters because as the Chief Judge is raising this question about public, and the Commission raises this question about public spirit versus private interests. And so this seems to me this is a really having an accurate description of how these projects are undertaken and in whose financial interest they are and when matters.
Can I answer the question in a slightly different way? Because I clearly wasn't quite getting where you were trying to go. And I think this does go to the same point, which is the distinction between the franchise and the certificate that Mr. Fish was talking about, in that in the context of a franchise, someone is competing for work. They're asking to be able to be the electric provider in a certain region or something like that. And there are multiple entities that are competing for that. Whereas in this case, that's not what's going on. And I think this is important because this is the distinction and the distinction that the Commission itself drew with the Alaska cases, in which both the Northwest Alaska and the other Alaska case involve expenses before the selection of the entity that was going to create that project. I mean, to be sure, that entity was going to make money off of the project, but that wasn't what the point is. The point is that it was They had been selected in that instance by Congress, as in this instance by PJM with FERC's approval to do so, at which point they were obligated to work on the project. And I think that's the critical point about when we're talking about how this is a necessary project to go forward. It's that someone else has decided that the project is necessary.
Is that why the commission's orders repeatedly refers to already approved? That's a significance to the commission, it looks like.
Yes, Your Honor.
In a number of the paragraphs, it talks about an already approved project.
Yeah, exactly, Your Honor. Your Honor. And one more point on the last point to Judge Pillard about the cancellation, which you had raised before, which again, to our mind is completely irrelevant because it's the same thing. While they were told that this project was a necessary thing for the reliability of the network by PJM, they worked on it. PJM decided it no longer was necessary in light of the 2008-2009 recession and a significant decrease in energy usage, and therefore they stopped working on the project. But that was not something that PATH decided. It had nothing to do with these certificates. It had to do with the overall network in the entire region, which PJM, not PATH, decided rendered this product no longer important, and therefore they stopped at that point precisely and stopped billing to the PJM ratepayers as a result of that.
Is it possible that franchise has a different meaning? You know, when I think of franchises, I think of McDonald's. And I don't know that, or Taco Bell or whatever they are, and you don't need a public official to get the approval to open up a McDonald's. At least I don't think you do. Are there franchises that are doled out to public utilities that are not doled out, but they enter into contracts that are private?
Not in this context, no. I mean, that's why in 426.4 it talks about the approval, modification, or revocation of franchises. That's a governmental action. I mean, the way in which the term is, I think, used similarly in that context is that most McDonald's franchises are exclusive in a region. That's what you're getting, is the exclusive right to be the McDonald's owner in Northwest DC. So to here, a franchise would be an exclusive right to provide electrical service in Northwest DC in that example. Whereas here we're talking about a cable that in no way, a transmission line that the approval of would in no way prevent another line to be approved. It doesn't directly connect to.
It would, though, prevent someone else from building that line. I mean, they're not going to do two lines. So in a sense, and I think that FERC uses the term loosely this way in the record. They talk about getting the franchise, meaning, getting the job, referring to actually PJM's selection of path for this line. So it does seem like there's a, I mean, at best it's ambiguous. So there's that. On the question of whether it's sort of public or public spirited or not, I mean, there's really there's a kind of a federalism issue here. The 426.4 public officials can be state officials or federal officials. And with respect to the state officials who have to grant the public certificates of public convenience and necessity, this was not an already approved project, right? There's a public interest that has yet to be satisfied. That's a state level public interest, right?
Yes, Your Honor. I agree that there is a approval process that the state has to go through. It is not a selection process. It's a process. But yes, there is, of course. But this is where the terms of the regulation are, I think, controlling. They don't address that. It is also the case that if you use the political nature language from the later note in the advertising thing as an overall description here, I mean, the selection of who's going to provide service is a much more political choice than do you license someone to build something that isn't preventing someone else from doing so. But again,
I mean, when you talk to people who, I mean, I think like the pro se petitioners in this case, when you talk to people who are affected by those decisions, they're very political, very political. The public Service Commission, the commissions, and whether they're going to grant these certificates of public convenience and necessity, whether, what kind of demand is counted, and do we really need this, and should we pay for it? Very political, no?
In a lay sense of the term, certainly, but in ISO New England and in this court's Braintree decision, the commission and then this court discuss how, in the context of an RTO or ISO approved project, another entity has made the determination that this is in the interest of the ratepayers of the entire network. And that's what all that is happening here is the implementation of that. It's not a decision being made by PATH in its private pecuniary business interest. PATH is executing a decision made by the nonprofit PJM that is responsible for all electricity in a 13-state region, and determined that this project was important for all of the electric users in that region.
Okay. Let me make sure my colleagues don't have additional questions for you, Mr. Gossett. Thank you.
Thank you, Your Honor.
Ms. Newman, we'll give you a rebuttal time. You have 2 minutes.
Thank you, Your Honor. I would like to point out that on rehearing, the commission ignored evidence that the coalitions in Pete were for the purpose of recruiting business and union leaders using quid pro quo arrangements and sponsorship money to represent past interest in the state public hearings. These weren't informational efforts. I would also like to point out that the Braintree case, that was a stated rate case, and that was about making a recoverability determination. Could the commission include account 426.4 in the ISO's rate? Now, past case is a formula rate, so it's an accounting determination, as the commission has said. So there you only have to find the proper account. So the Braintree case is completely different from this, because accounting determinations are completely different from recoverability determinations and when they are made. Another thing, I would like to point the court's attention to something the commission said in its opinion number 554 at paragraph 53, that's in the joint appendix at page 353. The commission said that there was no precedent for such a narrow interpretation of the first clause, or a rigid separation between the influencing of public opinion and the influencing of public officials. In fact, none of the relevant precedent made such a narrow determination. Instead, in all of these cases, the commission's interpretation of the language was broad, and this aligns with the commission's order number 276 that said that the interpretation of the language of the account should be made in its broadest meaning. In his concurrence, Joint Appendix page 298, Commissioner Black said that he was fearful that too restrictive an interpretation of the language of the account would allow utilities influencing expenditures to be lost in the recoverable operating expense accounts. Commissioner Black's fear has been realized in this case. A narrow interpretation of the first clause and opens the door to exclude a utility's influence on a whole world of utility expenditures that are not included in that very short list, things like a rate case. Ratepayers should not have to pick up the tab for a utility's influence of public opinion and public officials to increase the rates they pay. And I see that my time has expired, so thank you very much.
Thank you, Ms. Newman. Thank you to all who presented arguments this morning in this case. We'll take this case under submission.
This honorable court is now adjourned until Monday, September 13th at 9:30 a.m.